One of the biggest mistakes that people tend to make in Florida family law is assuming that any proposition, any statute, any case law, any bright line rule even is easy or simple or somehow straightforward and automatically applies to their case. Family law is a broad area of law that involves depositions, trials, mediations, a multitude of hearings, discovery requests, all the way across the board. Part of this involves, in some cases, when one spouse has suffered an injury and has received an accident or personal injury award during the marriage. During the marriage can also mean a variety of things. Did you suffer the injury before the divorce proceedings started? That could be relevant. Did you suffer the injury after the divorce proceedings started, but before a final judgment or a trial has occurred? That could be relevant. All of these things are a matter of fact. And one way of helping to classify whether a personal injury award acquired during your marriage, again, whether that has a specific meaning, an arguable meaning, or a bright line rule for that particular judge or that particular district court of appeals, or even the Florida Supreme Court, may be open and subject to interpretation. Having said all of that, let's read just a little bit of case law that helps identify the principle set up by the Florida Supreme Court, as well as the fact that Florida follows something called the analytical approach, not the Unitarian approach. And what is the analytical approach when it comes to suffering a personal injury, then undergoing a divorce process, and the equitable distribution of your marital assets and liabilities? Here we go from Roth versus Roth, a relatively new case which explains a variety of issues and beautifully addresses them with case law, logic, reason, and great facts piled on top of one after the next to create a brilliant opinion. Love it, hate it, like it, anywhere in between. This is a terrific and a tremendous opinion. Here we go. In classifying personal injury awards acquired during the marriage, Florida follows the analytical approach as set forth in Weisfeld versus Weisfeld, which considers the purpose of the portions of the personal injury award, or the amount that you ultimately recover as a result of your auto accident, personal injury, you have a slip and fall, a finger is cut off, something else is gruesome. In one of these cases, somebody drank something from a restaurant that caused corrosive damage to their esophagus. The purpose of the portions of the personal injury award, when classifying them as marital or non-marital, under the analytical approach, the marital property subject to equitable distribution for your injury award includes 1. The amount of the award for lost wages, 2. Lost earnings capacity during the marriage of the parties, and 3. Medical expenses paid out of marital funds. What is a marital fund? Is it commingled? Does it have to be commingled? Is it automatically marital? Does somebody have to prove that it's non-marital? All of these things are going to go into your case. This is next level, high level thinking. The non-marital property belonging to the injured spouse, again, non-marital property as in not subject to equitable distribution, includes the portion of the damage award for pain and suffering. Also, other case law makes it clear that future lost earnings when you're not married and you're already divorced should not be included in equitable distribution today, and the court does not have some crystal ball as you would see in Lord of the Rings, Rings of Power. One more time. The non-marital, as in not going to be distributed, not going to the other side, belonging to the injured spouse, includes the portion of the damage award for pain and suffering. Have you broken your neck? Have you had severe disc issues from an automobile accident or some other gruesome injury that nobody ever wants to suffer or think about? That is not subject to equitable distribution. We can theorize as to why that is the case. Perhaps one reason is that party is going to need money for future medical bills and to perhaps find ways to enjoy life when they are dealing with a substantial and severe injury. This has been another episode of the Best Florida Family Law Podcast. Nothing described or said here today constitutes legal advice. This is simply for informational purposes, for entertainment, and as I always say, to give the general public a greater sense of what family law is and the unique and brilliant legal issues contained therein. Thanks, everyone.